Hello and welcome to our sixth episode in our lessons on the law of tort. We hope you've benefited from the last 5 episodes, and we hope you enjoy this one as well. In our previous episode, which was episode 5, we examined the tort of malicious prosecution, where we stated that 5 elements need to be proved in order to be successful. In this particular episode, we will look at the rule in Wilkinson V Downton. We are going to identify the elements in the rule in Wilkinson V Downton and highlight the major principles you would need to explain these elements to help you appreciate how to apply them. Now, this is a case where the decision in which the common law first recognized the tort of intentional infliction of mental shock. The intentional infliction of mental shock. At the time, this was not covered under the tort of negligence. Now let's look at some brief facts on this particular case. Thomas Wilkinson was the landlord of the Albion Public House in Limehouse in London. A regular customer of the public house, named Mr. Downton, decided to play a practical joke on Wilkinson's wife when Mr. Wilkinson went to see the races in Harlow, Essex. He left his wife to manage the house. Downton approached Miss Wilkinson and told her falsely that her husband had been seriously injured in an accident. He said that Mr. Wilkinson had suffered 2 broken legs and was lying at Elms in Leytonstone. He told Mrs. Wilkinson that she should go to her husband in a cab and bring 2 pillows to carry him home. The effect of Mr. Downton's statement to Miss Wilkinson was a violent shock to her nervous system, causing her to vomit and for her hair to turn white, among other more serious and permanent consequences. These consequences were not in any way related to any history of bad health or weakness, and there was no evidence of predisposition to nervous shock or any other idiosyncrasy. Mrs. Wilkinson sued. Now let's look at this. What then was the rule developed from the case? The rule created an action on the case for intentional infliction of physical harm by indirect means. Briefly put, it states that any act done willfully, calculated to cause physical harm, and actually causing physical harm to another, per Wright Janvier versus Sunni, is an actionable wrong. The elements we get from this particular case, that is, are as follows. 1. The rule created liability for the cause of harm through indirect means. You can see Wainwright versus Home Office. Thus, the elements to prove as laid by Wright J in the case of Wilkinson versus Downton are: there must be an action done willfully. The act must also have been calculated to cause physical harm to the plaintiff. And lastly, the act must actually cause physical harm to the plaintiff. Let's look at the first element. The act could be either false words or threats as put by Bankes LJ in Janvier versus Sweeney, or an act done deliberately, or a misrepresentation. Any of these must go to establish the willfulness of the act, and as rightly put by Wright J in the case, there being no justification alleged for the act. As Wright J said, the act could go to infringe on the personal safety of the plaintiff. Now, one may ask, what if the act done was incessant phone calls or such mode of communication? Answering this question, it was held in Barnett versus George per se Arnold that unless the plaintiff successfully proves any impairment, damage, or injury to his or her health, the chances of being successful under this rule is minimal. However, in Khorasanjian versus Bush, the plaintiff succeeded on the Wilkinson versus Downton principle because of the risk that the cumulative effects of continued and unrestrained phone calls could cause physical or psychiatric illness. Take note that the part of the principle in the case which says that the proprietary interest, or at least in some cases exclusive possessory rights, is not necessary to establish a claim of the rule in Wilkinson versus Downton, was overruled by the case of Hunter versus Canary. On the second element, which is calculated to cause physical harm, from the decision of Wright J. in Wilkinson versus Downton, the defendant's act must be so plainly calculated to produce some effect of the kind which was produced that an intention to produce it ought to be imputed to the defendant, regard being had to the fact that the effect was produced on a person proved to be an ordinary style of health and mind. Hence, therefore, an intention to produce such an effect must be imputed, and it is no answer in law to say that more harm was done than anticipated, for that is commonly the case with most wrongs. To be able to prove that the action or the act was calculated to cause physical harm, it must be established that the act or words were uttered with the knowledge that they were likely to cause harm, as held per Biggs LG in Janvi versus Sweeney. However, an action does not lie in the rule in Wilkinson versus Downtown if the statement or an act is made honestly in good faith, as held by Lord Denning in DV versus National Society for the Prevention of Cruelty of Children. On the last element, which is the act must actually cause harm to the plaintiff or the person to whom it is directed, it was said in Burris versus Azadani that a cause of action will only lie in the rule if the act or the acts are directed at the plaintiff. In the words of Wright J. in Wilkinson versus Downton, the willful injury is in law malicious, although no malicious purpose to cause harm which was caused, nor any motive of spite is imputed to the defendant. So one may ask, what is the class of injury that will fall under this rule? In Wainwright versus Home Office, Lord Hoffman identified one of the class of injury in the following words: to succeed in an action, the rule in Wilkinson versus Downton, the plaintiff must prove an intention to cause physical injury, an actual physical injury amounting to recognized psychiatric injury and not mere distress. So in conclusion, we would say that one thing we all need to take away from this rule is this: engaging in April Fool games are dangerous, and you may be opening yourself up to be subjected to this rule if it is found that all the three elements discussed in this particular episode are established against you. So this is the end of our 6th episode. We hope you learned and will join us for our next session, which will be a revision on all 6 episodes brought to you. Again, we must plead with you to share, like, comment, and subscribe to our channel. Thank you very much.